president of our college here, Dr. Cal Dawson, members on our platform, Dr. Max Hilaire, our guest speaker for this evening, Dr. J.S. Archibald, our moderator, ladies and gentlemen. It's my pleasure to welcome you here this evening as we continue in our public lecture series here at H.L. Stout Community College. We would dispense with most of the formalities. We have a small, intimate group, as I've invited persons who are seated at the back to come forward. So those persons who came in later, if you can join us down at the lower level, that would be greatly appreciated, as I think that it makes it easier in terms of our interaction. It is my pleasure to chair this evening's proceeding and to say a special thanks to Dr. Hilaire in particular, who has agreed to come and to speak to us this evening on a very important topic, one which we have not paid much attention to in these Virgin Islands. In fact, when I look back into our history and I look in terms of our varying constitutional commission's report, we would see that there were, in fact, sometimes a brief thought about it, the issue of self-determination. This evening, we are privileged to have Dr. Hilaire with us, as he indicated that he has lectured internationally. He's from Morgan State University, and he has lectured all over the world, but he's not really spent much time lecturing in the Caribbean. And in that vein, I would like to also say thanks to my colleague, Mrs. Lynette Barr, who was able to get him to come and to be with us this evening, and we greatly appreciate that. And also for me to say a special thanks to Dr. Archibald, who has agreed to moderate this evening's proceeding. I take it that I would leave that as the formalities. We are quite eager, and we really want to hear what these gentlemen would present for us this evening. Dr. Archibald, as moderator, would set the pace, and then we would invite Dr. Hilaire to make his presentation. So I'll turn over to Dr. Archibald.
Thank you very much, Dr. Smith. Ladies and gentlemen, it was a great pleasure for me to meet Professor Hilaire. And immediately, within 30 seconds of meeting him, we were discussing familiar matters. And I asked him how his case was going in the International Court of Justice. And he immediately told me, well, look, this case has brought me death threats. I said, I expected to. As a member of Human Rights Committee in London, I have been following up the case. But he'll tell you perhaps not about it. If he doesn't, when the question time comes, I'll ask him about it. I am delighted to have an international lawyer in practice here tonight to discuss a subject which we have not discussed. The Virgin Islands people are interested in this subject of self-determination, but nobody has yet discussed it at depth. The politicians have rightly not touched it yet. It's not the kind of subject you touch except in depth and except that you want the end product to be self-government, independence, sovereignty, or whatever. I have had the great pleasure of dealing with this subject up and down the Caribbean with those who are already independent. And Professor Hilaire travels internationally to deal with international law, although he hasn't been in this part of the Caribbean to deal with this subject. So tonight, without keeping you waiting, I'm going to invite him to come and discuss this subject. My remit is simple. The letter says to me that the purpose is to formally invite you on behalf of the Board of Governors and the President of the College to be the moderator of our upcoming public lecture here at the institution, to be given by Dr. Max Hilaire of Morgan State University. Actually, is known throughout the world as Professor Hilaire. The topic for the lecture is International Law and the Right of Non-Self-Governing Territories to Self-Determination, the case of the BVI. As moderator for the evening activity, you'll be required to give, and they gave me 4 things to do. You'll be required to give a general introduction of the topic. 1. Set the ground rules for the discussion that will follow. That's 2. And during the discussion session, you will also be required to direct questions from the audience to the speaker. I would have thought sometimes the speaker will direct questions to Dr. Hilaire. And lastly, help to stimulate the discussion. We are hoping that the topic will generate public interest and spark a much-needed debate that will filter into the community. I think we have a very fine, small audience. Everybody who's coming here tonight is interested. Nobody has simply strayed in. And I hope that when the discussion time comes, we will get concise, direct questions. The whole question of international law is not one which has become profound in the Caribbean yet, but here we are, a maritime country, an airline country with 3 potential airports, and a country involved in international commerce to the extent that we have shaken the foundations of the major countries. Those things are governed by international law. And the questioner, or the question tonight will be international law and the right of non-self-governing territories to self-determination. The United Nations has a particular chapter, a particular article dealing with this subject. And in order that Professor Hilaire will not have to waste time to deal with it, I thought in introducing the subject, I would refer to Article 73 of the United Nations Charter, which sets it out clearly, because every year a committee in the United Nations reports to the United Nations on this subject. As you know, the United Nations was born in 1945. It's headquartered at New York. It sits every day, 7 days a week, 366 days every leap year. Extremely busy. Article 73 gives the remit for this subject. It's put in very stark terms. It reads as follows. And you know, every country in the United Nations has 5 representatives there, at least 5. No more than 5. Members of the United Nations which have or assume responsibilities for the administration of territories whose peoples have not yet attained a full measure of self-government recognize the principle that the interests of the inhabitants of these territories are paramount, and accept as a sacred trust the obligation to promote to the utmost within the system of international peace and security established by the present Charter the well-being of the inhabitants of these territories, and to this end, A, to ensure with the respect for the culture of the people concerned, their political, economic, social, and educational advancement, their just treatment, and their protection against abuses. B, to develop self-government, to take due account of the political aspirations of the peoples, and to assist them in the progressive development of their free political institutions, according to the particular circumstances of each territory, and that is important, according to the particular circumstances of each territory and its peoples, and their varying stages of advancement. C, to further international peace and security. D, to promote constructive measures of development, to encourage research, and to cooperate with one another, and when and where appropriate, with specialized international bodies, with a view to the practical achievement of the social, economic, and scientific purposes set forth in this article, and to transmit regularly to the Secretary General for information purposes subject to such limitation as security and constitutional considerations may require, statistical and other information of a technical nature relating to economic, social, and educational conditions in the territories for which they are respectively responsible, other than those territories to which Chapter 12 and 13 apply. Professor Hilaire, every year the reports are made to the United Nations, as you know. Some of them are short, some of them are very big. I do not know what they report about the BVI, but I don't think the reporters understand the BVI. Never in the history of colonialism, and I say this without fear of successful contradiction, never in the history of colonialism has a small country like the Virgin Islands shaken the foundations of the economic world. The World Bank report of 2008 said that 1/6 of the foreign investment in China, modern China, comes through companies registered in the British Virgin Islands. This year, on the 30th of January, the Privy Council gave a judgment of a case coming out of Turkey, and with AT&T, gave it here relating to a judgment which came from our courts here, our commercial court. 30th of January this year, Privy Council judgment relating to $1.3 billion. And as I told the journalists of the BVI, no journalist has reported about it because they don't understand it and they don't want to. I think they will start to try to understand. They report petty crime or crime. This country, the BVI, is an international country, a colonial country. And when we get into the discussion, I will tell you, it is at the same position today in the world as America was in 1704. When the great parliamentarian Burke stood up in the Houses of Parliament and told the British, look, don't mess around with what you call a colony. It is exporting from America more than you import from the rest of the entire world. And so I think those who talk about us as colonials and those of us who interfere with our economic authority have not studied history of colonialism. This is an economic and not a political country. And I hate to tell you that, Professor Hilaire. I don't know what you're going to say, but I invite you to say it right now. Thank you.
Good evening, everyone. I don't know if I could replicate what Dr. Archibald has said, and I hope I can shed some light on some of the issues he mentioned, particularly the last one in terms of the current position of the BVI in the international financial market and some of the transnational legal issues surrounding these offshore trusts and insurance and various financial instruments that are operating from the British Virgin Islands. Again, I'm delighted to be here. I've said to some of the people I've spoken with, my only visit to the British Virgin Islands was some 39 years ago, and never had any reason to return, and I regret it very much. I should have come earlier. Maybe I should have invested 39 years ago, and I would be reaping the benefit of my investment now. But I promise my wife, who is here with me tonight, once we relocate to the Virgin Islands in the next few years, that we will make regular visits to the British Virgin Islands, not to look into our trust, our various financial instruments, but to enjoy the beautiful beaches, the people, and the island in itself. I want to just at least acknowledge a couple of people for getting me here. First of all, I want to say thank you to Lynette Barr, who was a former student at my university and was really persistent in trying to get me to come to do a lecture at your university. And I promise her in between schedules between the US and Czech Republic, whenever I come to St. Thomas, I will make a trip to the BVI, and I'm happy we finally work it out and I can be here tonight. I also wanted to I also want to thank Dr. Smith for his hard work in organizing this event and making it all possible. And I want to thank the audience for coming out. I know some of you could have been in St. Thomas for Carnival, or some of you could have been doing something else, or just basically stay home. But I appreciate the time you take to be here and to have sort of a dialogue on a topic I think not only important to you, but to us in the diaspora as people of African descent in the Caribbean, and also relevant to the people in Africa as well. This is a global issue. The right of self-determination is not unique only to people in occupied territories, but it's also important to groups that no longer feel they could coexist, whether it's in Europe or in Africa. There's a situation in Spain, in Scotland, and Britain are now going over this whole issue as to whether Scotland wants to break away from the kingdom. In so many other territories. Recently, we saw South Sudan, after many years of war, breaking away and exercising their right to self-determination. So this is an issue on the agenda. It's not going anywhere anytime soon, in as much as we may feel the international system is exhausted of sovereign state. But it is something fundamental to human beings, that whole issue of the right to self-determination. It's a moral issue, why it was placed in the Charter of the United Nations and why it was placed in the Peace of Westphalia, which is the foundation for the current international legal order that we are living under. So what I'll do is to give a general framework of this whole concept of self-determination under international law, this whole issue of colonialism, the justification, the legal basis for colonialism, and why I think today it's either illegal, immoral, or unethical for one group of people to preside over another group of people. The solution is not saying you need to be an independent country, or you need to shift your loyalty or whatever. If it's convenient for you, fine. But it's the whole issue, the morality and the ethical part of this, and also the legal justification that no longer exists, is what I intend to address tonight. Some 36 years ago, the UN Commission, which Dr. Archibald talked about, visited the U.S. Virgin Islands during Carnival. It was April of 1977. And I was still just about getting ready to go to college when I was invited to that event, and for curiosity, I went and testified before the UN Commission on Decolonization in 1977, calling for some kind of adjustment in the status of the U.S. Virgin Islands. I was blasted in the newspapers as a result, and many felt it was crazy of a college student to call for self-determination or the right to independence. That was not the issue. The issue was really having a discourse on where do we go in terms of the legal status of the Virgin Islands. And that should also include the French islands, the Dutch islands, and whoever else controls territory in the Caribbean and elsewhere. So what I want to speak about tonight is really, it's not about the economic situation of your territory. The issue is on the legal, the ethical, and moral aspects of the relationship between the British Virgin Islands and the British government under international law. I'm keenly aware of the economic situation on the island, but my speech is not about economics. And the BVI, Bermuda, the Cayman Islands, and other British territories are doing quite well economically in comparison to their independent neighbors. The BVI has a higher per capita income than most of the independent nations in the Caribbean. Its citizens enjoy travel privileges, human rights under the European Convention on Human Rights, and those rights far exceed that of those in the U.S. Virgin Islands or in other in independent Caribbean countries. More importantly, the BVI has enjoyed tremendous economic growth that is the envy of the rest of the Caribbean. Whereas Caribbean nations are experiencing economic decay, the BVI economy is thriving. In fact, it is not surprising that so many other Caribbean nationals have flocked to the BVI for employment opportunities. Hence, one can ask, if the situation in the BVI is far superior to that of its neighbors, why should it seek a change in its status from colony to an independent nation? But as I said before, my speech is not about economics. It is not about the current financial situation in the BVI. It is legal, it is a moral issue, and a legal issue. And it is the crux of this colonial relationship and the justification for continuing British rule, which was predicated on a false legal premise initially. And that should go also for the French, for the US, the Dutch, and anyone else. So I'm not singling out the British territories for this debate, even though the discussion here would center more on the situation in the British Virgin Islands. The international legal order that authorized European powers to colonize what I would consider the orders has its roots in the Peace of Westphalia established in 1648. It is based on a false assumption that non-Western peoples were uncivilized and barbaric, and that European colonialism would bring them into the fold of modernity. We all know what happened after Europeans encountered the others. There is an element, to a certain extent, of racism in this development and expansion of international law, which operated under double standard, one for Europeans and another for the other peoples of the world. The Peace of Westphalia was intended to settle the 30 Years' War between Protestants and Catholics, and to create a new order in Europe, not the kind of international community we have today. The treaty abolished the authority of the Holy Roman Empire and made the former warring parties in Europe all sovereign states. Under Westphalia, states were considered equal. They were sovereign. Their internal and external matters were governed by the local authorities, and there were no higher authority over the central government in each state. States were prohibited from intervening or interfering in the internal or external affairs of other sovereign states in Europe, but they had the freedom to colonize other countries or other territories. More importantly, the state and its officials were immune from prosecutions for crimes committed against the others, that is, people in Africa, Asia, the Caribbean. Above all, it gave all peoples the right to self-determination, which was restricted at the time solely to the various ethnic groups in Europe. The new order in Europe did not extend the same rights and privileges to non-European people. In fact, non-Europeans were treated as objects instead of subjects of international law. Since the Peace of Westphalia did not recognize peoples in the rest of the world, it basically gave Europeans the freedom to invade and to colonize non-Western peoples. The Westphalian legal order was created for Europeans, or by Europeans, for Europeans. The law that emerged from Westphalia was one that did not recognize territories outside the boundaries of Europe. And the international law of the 18th and 19th centuries gave European states carte blanche to invade and to conquer other peoples and countries, and to treat the inhabitants as inferior and uncivilized. It also created a law of war that allowed Europeans to mistreat their captives after they invaded. European powers captured territories in Africa, in Asia, the Caribbean through military conquest and violence, what today would be considered either genocide, war crimes, or crimes against humanity. These activities of European powers were considered perfectly legal under the international law that existed during that period. So European powers were basically granted carte blanche, or a freedom to divide and occupy foreign territories. And it is this European hegemonic law that basically granted Europeans the right to go into other territories and proclaim it to be theirs. We should not forget the Berlin Conference of 1884-85, which basically divided Africa amongst various European powers. Nor should we forget the various conflicts that were fought in the Caribbean, in which territories change hands after every war. So basically, irrespective of who lived in the various islands of the Caribbean, after European wars, they basically trade territory from one European power to the next. So it is not surprising that you find in some islands they speak English, they speak French Creole, some speak Dutch, some were neutral, some were Spanish at some point, some were Portuguese, and what have you. It is the European hegemonic law that also imposed treaties that violated the rights of the others. And it is this hegemonic law that justified slavery and stripped the others of their national identity. And finally, it is this hegemonic law that proclaimed Columbus discovered the Caribbean and the Americas. When Columbus was lost, he made a mistake, felt he was in India, and simply called us the West Indies. So in many instances, especially if you go to the UK, they call people of Caribbean descent West Indians. And I've always objected to the identification of West Indian because I'm not Indian. And I do not want to continue to validate a mistake Columbus made to give credit to someone who did not discover the Caribbean when there were Caribs and Arawaks in the region. Currently, the BVI government serves at the discretion of the British Crown, who exercise sovereign authority over the island. It is Her Majesty's government, not the government of the people of the BVI, even though the people participate in a mock election or some form of election in which you are told you elect representatives. The government lacks sovereign authority, and its legislation must be approved by the Governor General, who represents the Queen. The mere presence of a white Governor General in an island that is predominantly black is a reminder that the BVI belongs to Britain, not the people of the British Virgin Islands. The Queen or the UK government has absolute veto authority over all legislations adopted by the BVI Parliament. And final judicial authority rests with the British Supreme Court or the Privy Council, as Dr. Archibald mentioned, not with the courts of the BVI. The colonial wars in the Caribbean left us very divided. The islands so close and similar, yet so divided by language, political loyalty, and superficial barriers that were created by the various colonial powers. The occupation of the Caribbean and other countries was considered perfectly legal under international law, because, as I said, the law made by Europeans for Europeans, so the peoples of the other parts of the world had no say. That same law allowed the countries to consider, under international law at the time, as objects and not subjects of international law. It is this law that is being challenged today as illegitimate, as it was crafted without due consideration given to the concerns of the inhabitants of territories in Asia, Africa, and the Caribbean. European international law would identify territories in the Caribbean and elsewhere as terra nullius, or virgin territory, or what is popularly referred to today as no man's land. Indeed, there seems to be some element of racial superiority in this colonial conquest. And it is precisely for this reason that in 1960, a group of developing countries from Africa, Asia, took the lead in the United Nations General Assembly to adopt Resolution 1514, which delegitimized colonialism. The resolution called for the granting of independence to all non-self-governing territories. The Assembly vote accelerated the demise of European empires, particularly the British Empire. Between 1960 and 1980, more than 120 countries gained their independence, ending more than 350 years of colonial domination. The General Assembly's vote was a historic moment in international relations, as a non-binding resolution of the United Nations helped transform the international system from a predominantly European world order to a genuine international community where diverse voices, cultures, religion, political tradition could all interact and coexist as equal in this new post-Second World War international legal order. With a majority in the General Assembly, developing countries introduced a series of measures that would transform international law as well. The resolutions include permanent sovereignty over natural resources, in that the resources of the countries of Africa, the Caribbean, belong to the people and not to the multinational companies that initially owned them. Second, the inadmissibility of intervention of any kind, military or otherwise, in the internal and external affairs of member states of the United Nations. Third is a definition of aggression, in which any crossing of borders by the military of a foreign power into the territory of another state would be considered an act of aggression. Fourth, the rights and duties of states to respect the sovereignty, territorial integrity, the independence of all member states of the UN. And finally, the General Assembly resolution on friendly relations and cooperation among all states, which basically reaffirmed principles of the Charter of the United Nations. And Dr. Archibald mentioned Article 74, which affirmed the rights of self-determination for all non-governing territories. I should include in this transformation that was brought about by the General Assembly the 1948 Universal Declaration on Human Rights, which recognized and affirmed the rights of all peoples to self-determination. Similarly, the 1966 International Covenant on Civil and Political Rights, which again recognized the rights of all peoples to participate in the formation of their government and to have that right of self-determination. These various conventions recognize the rights of all peoples as equal, regardless of race, class, national origin, or gender. And this change in the international legal order would subsequently treat colonialism as morally repugnant and completely unacceptable under international law. Indeed, since the passage of General Assembly Resolution 1514, colonialism is considered illegal, and the peoples of all non-self-governing territories have the right to self-determination as recognized under international law as a fundamental principle of international law which one cannot derogate from. And the International Court of Justice, in the Kosovo advisory opinion, which was handed down about 2 years ago when Kosovo declared its independence from Yugoslavia, Russia and China and several other states refused to recognize the rights of the people of Kosovo to self-determination. The General Assembly requested an advisory opinion from the International Court of Justice to simply clarify what is the rights of a people under international law to self-determination and to declare themselves an independent state. And the court was very skillful in crafting its advisory opinion in recognizing that there is no prohibition in international law to any group of people declaring themselves an independent state or to exercise the right of self-determination. That comes from the internal rule of the people, not from above. But what this advisory opinion did was simply reaffirm the rights of people irrespective of what international law said, because I think the court recognized the origin of international law, which initially justified the imposition of colonial rule over peoples of other territories. And more recently, we saw South Sudan, which frankly is an extremely poor part of the world and part of Africa. But the people fought a bitter war with North Sudan, which is predominantly Muslim and Arab, to win their right to self-determination and to become an independent country. Yes, South Sudan is bare, it has limited oil resources, but there is no infrastructure. Most of the people are not educated. South Sudan literally is totally bare, but the people felt they had that right to free themselves out of Arab and Muslim domination, and hence recognized by the international community as the newest member state in the United Nations. Colonialism can be considered an illegal form of occupation, just as when a country invades another country and occupies that territory. It dehumanizes the colonized and forces them to internalize their oppression and feeling of inferiority and alienation. In short, colonialism is racism. And I would urge you to take a look at the works of one of our fellow Caribbean distinguished scholars, Frantz Fanon, and also Aimé Césaire, who was the former mayor of Martinique, was responsible or one of the pioneers of the field of negritude, who passed away just a couple of years ago. There is no longer a legal justification for continuing colonial rule. This feeling of alienation generated by colonial rule can ultimately breed resentment and eventually a violent response from the colonized, as was the case in Algeria, Angola, Kenya, Mozambique, and Guinea-Bissau. In fact, when the peoples of these various countries rose up against colonial powers, there were bitter wars fought against them for many years. And the colonized powers did not think these people had a legitimate right to fight for their self-determination and independence. In fact, the General Assembly had to, in turn, adopt a resolution recognizing colonial conflicts as international conflicts, and then calling on member states to provide assistance to liberation fighters. Similarly, there was a move by the majority of African states at the time to amend the Geneva Conventions of 1949 to recognize the rights of those liberation fighters fighting war to be treated as legitimate combatants, and if captured, to be given the same protection as those fighting on behalf of an independent state. In the case of the BVI, one would argue that the territory is too small to be independent and, like its neighbors, would not be economically viable. While one can safely say that Caribbean independence has made a mockery of the Westphalian conception of sovereign equality of state, one could also argue that Jamaica does not have the same equal status as the United States, or Grenada, for example, which owes about $1 billion to international financial institution, simply does not have the independence that it claims to have. Many of the Caribbean countries and also many of the developing countries are vulnerable to global economic shocks and may find themselves in great economic difficulties and under the supervision of the International Monetary Fund. Most island nations are struggling to stay afloat and to participate in the global economy that is increasingly dominated by multinational corporations, big banks, and regional trading blocs. There's definitely no room for additional small island states, and there's certainly no room for additional new states either. But in a globalized world where borders are becoming increasingly porous, what is needed is not the Westphalian model of more sovereign states, but a new paradigm that incorporates all states, non-state entities, into the global community with peoples of each territory at its core. Because if you look, Europe is moving away from this concept of sovereign states. They realize it does not solve all their problems, and hence they formed the European Union, which is more viable economically and certainly can compete with the United States and China. So this whole concept of sovereign statehood is almost obsolete. So if one assumes that the solution to the BVI current status is to move towards being an independent country, that's not what I am advocating. It may very well be the solution to the current predicament of the BVI, Turks and Caicos, the US Virgin Islands, the Dutch Antilles, and the French Islands. But what that would do, if we were to move closer to a more diverse international community that would embrace the non-self-governing territories, territories that are not economically viable, is to afford them the same rights and privilege in participating in all aspects of international life. Currently, occupied territories are recognized or represented by, whether it's the United States representing the people of the Virgin Islands or Britain representing the people of the BVI. The people of the BVI and other non-self-governing territories would enjoy their full rights as subjects of international law instead of the current status as objects of international law. In fact, the current colonial regime is a reminder of the bygone days of 300 years ago. We are talking tonight not about economics, as I indicated at the beginning, but about legality and morality and the international representation for the peoples of the British Virgin Islands and other non-self-governing territories. Currently, the authority to manage the affairs of the BVI in the international arena rests with Britain. The people of the BVI have no international representation and cannot make claims independent of the British government. The BVI cannot participate in international fora that may affect them. It is this legal right that colonialism denies the people of the BVI. Colonialism gives Britain that legal authority to do whatever it so pleases with the BVI and its inhabitants. And a good example would be what happened to the people of Diego Garcia in the Indian Ocean when the British government basically uprooted the entire population of that colony and moved them to someplace else and gave the island to the United States to establish a naval base. More recently, that island was used for torturing suspected terrorists captured by the United States in the War on Terror and brought to Diego Rivera, where they were tortured and forced to give confessions before they were transferred to Guantanamo Bay. The people's right to return to their ancestral homeland has been rejected by the UK government and by the British High Court. Similarly, the British government replaced the government of the Turks and Caicos Island because of allegations of corruption. And then when the Prime Minister of Bermuda on humanitarian grounds, decided to accept 6 Chinese Uyghurs. These were innocent Chinese, picked up ethnic Chinese, picked up in Afghanistan and transferred to Guantanamo Bay. The US government decided there was no legal basis to continue to hold them, asked the government of Bermuda, and it was basically a trade-off that if you accept these Uyghurs, we will not have the SEC scrutinize your offshore financial activities as we intended to do. The Prime Minister accepted these 6 Uyghurs. The British government retaliated by forcing the Prime Minister out of office. This whole issue of the rights of the people versus the rights of the British government or the governments that occupied non-self-governing territories is at the core of this colonial regime. All peoples, as was indicated by Dr. Archibald, under the UN Charter, the Universal Declaration on Human Rights, the International Covenant on Civil and Political Rights, are entitled to self-determination. It is a moral right. In a world that has greatly transformed since the end of the Second World War, the justification for colonialism is no longer valid. The occupation of the BVI by Britain is not in the interest or the welfare of the people of the BVI. It is intended to serve British interests in the Caribbean. And the thriving offshore sector, which I mentioned at the beginning, in the BVI, represents a manifestation of this new form of colonialism in non-self-governing territory. So it's not coincidental that with a population of just about 25, 27 million people, that you have 1 million registered offshore companies of various kinds in the British Virgin Islands. The others are in Bermuda, similar status, Turks and Caicos Island, similar status, Cayman Islands. Now, you ask, why choose the non-self-governing territories to establish these very sophisticated, complex financial instrumentalities? And who are the people who are opening these trusts and various kinds of instrumentalities in the British Virgin Islands? Are we doing due diligence on them, whether it's here, Bermuda, or elsewhere? And why did they choose non-self-governing territories instead of independent Jamaica, Barbados, Trinidad, or even New York, which is the world's greatest financial center? Everyone wants to do business on Wall Street. Why are some people avoiding Wall Street or the City of London and coming to these very secretive locations in the Caribbean, like we have a new modern form of piracy and buccaneer activities a la 1700? We need to ask this question because in many instances you're seeing, as Dr. Archibald mentioned, transnational litigation taking place against companies that are represented in the British Virgin Islands, but these cases are adjudicated in UK courts, in US courts, in French courts, in Swiss courts. And many of the individuals find themselves using these companies. They're not investing in the various non-self-governing territories, but it's convenient for them to open a company here and to use the name of the company to either conceal assets in Swiss banks in the name of the companies, as was recently discovered with the finance minister of Mongolia, who opened 2 companies in the British Virgin Islands. Then $8 million that was given to him as bribe by Rio Tinto, which is a major mining conglomerate from Australia and Canada, took that $8 million and put it in a Swiss bank account under the two companies registered in the British Virgin Islands. When it was discovered, because the International Consortium on Independent Journalists did a study of 70 offshore financial centers and discovered this individual, along with the daughter of former Philippines President Marcos, various individuals from Russia, Ukraine, Georgia, who had companies set up in the British Virgin Islands and using these instrumentalities to borrow from banks in England and Switzerland and then defaulting. The Guardian of London did a story on the British Virgin Islands, and it was headed "Beautiful Beaches and Lovely People and Bank Secrecy." So the finance minister of Mongolia found himself caught up in this scandal, and it has ruined his opportunity to be the next prime minister of Mongolia. So, as Dr. Archibald said, the journalists in the British Virgin Islands or in the Caribbean in general may cover some of the crime issue or some of the very local issues, but not the international issues that are indirectly affecting our reputation as a land of joy and beauty and peace. And I think eventually being caught up in this global financial sector, we in the Caribbean may find ourselves in a position like Cyprus, where the IMF, the European Union, and various agencies of the United States government, particularly the Justice Department and the Securities and Exchange Commission, may have to investigate some of the activities taking place in many of these offshore sectors. So we need to ask whether, in as much as this sector provides or generates tremendous employment for the people of the Virgin Islands, Bermuda, Cayman Islands, and Turks and Caicos, whether that is a sustainable and viable economic industry that will go on in the British Virgin Islands and elsewhere for a very long time. I'm not sure the authorities here and elsewhere in non-self-governing territories are fully aware of the identity of some of the people who claim to be investing in these financial instrumentalities. And the mere non-self-governing status of the British Virgin Islands is a conduit, sort of, for this modern-day form of either pirating or buccaneerism, and the sole interest of those who are using these offshore territories for their financial activities is to conceal their assets from or to evade taxes from the United States Internal Revenue or the British government or other governments in Europe. This is one of the consequences, and a major one, of continuing colonialism, and it is detrimental to the people of the BVI and other non-self-governing territory. Now, you may ask, what is the alternative to the current status? And frankly, as I have indicated, I'm not advocating independence, nor do I think it's a viable option for many of the non-self-governing territories. But I think the world is moving gradually into a more diverse milieu where we have independent states, non-independent states, various forms of entities, and even non-governmental organizations and international firms that are playing a very important role in international relations. One could ask to be placed under a United Nations trusteeship where people would be prepared for the long-term self-government, or they could enter into some relationship with the rest of the Caribbean. But there are any number of options that would make the Virgin Islands probably a more viable place and give people the right to represent themselves in the international community, which increasingly is imposing rights and obligations on people, and the failure of those from non-self-governing territories to participate in this new international legal order that is emerging is again to the disadvantage of the peoples of non-self-governing territories, and you in particular in the British Virgin Islands. So I will stop here and open up for discussion, and I expect to hear maybe a lot of criticisms to what I've said, but this is what professors do. They lecture and then you say whatever you want. I'm not going to grade you, so you won't be penalized if you oppose me or criticize me. Thank you very much.